Well, welcome and good afternoon. I'm Carla Stoffel, Dean of the University Libraries, and I'd like to thank you for coming to our second program in the Civil Rights in Arizona lecture series. This program, held in conjunction with the Special Collections new exhibit, explores how the fight for civil rights has impacted the local Tucson community. And I do hope if you have not had an opportunity to carefully go through the exhibit that you will take some time this afternoon to do that. Before I introduce our speaker, I'd like to thank Bob Diaz for organizing this lecture series and curating the exhibit. And I'd like to thank our friends of the University Libraries for their support of this and the other events that are held in special collections throughout the year. I'd like to also, you've got a Friends of the Library brochure, I think. I'd like to invite you to consider being a friend of the library. And you have our list of events, and I'd like to invite you to join us for the remaining two lectures in this series, March 7th, with Dr. Licona, Dr. Stephen Russell, and Jamie Lee, who will discuss Tucson's LGBTQ community, and on April 29th with Lupe Castillo and Margot Cohen, who will speak about Tucson's Mexican-American community. We're honored today to welcome back to the libraries today's speaker. Robert Williams Jr. is a member of the Lumbee tribe and is the E. Thomas Sullivan Professor of Law and American Indian Studies at the University of Arizona. He's the author of the classic work on Indian rights under U.S. law. It's the American Indian in Western Legal Thought, which won the Gustavus Meyer Human Rights Award. His most recent book is titled Savage Anxieties, The Invention of Western Civilization. He's the recipient of awards from the MacArthur, Ford, and Soros Foundations. He's also well known for his work in defending tribal groups before the United Nations and the Supreme Court. Now, Professor Williams was here in the fall. Last October, he served as our featured speaker at a well-attended Banned Books Lecture Week, and so today we're especially pleased he's come back, and we have the benefit of hearing him talk about Indian law cases, Arizona, and the Supreme Court during the Civil Rights era. So please join me in welcoming Professor Williams. And while I bumped something here and lost his program.
Got me started. Thank you so much.
He'll have to fix it.
That's good. Thank you for that introduction. And again, thank you. It's always a pleasure to come to the library and be able to talk to a larger campus audience, as opposed to just talking to law students who can be pretty depressed these days. So even in this 50th anniversary of the Civil Rights Act and commemorating the Civil Rights Movement. And so I was really excited when my former colleague at the Law College, who now works here at the library, Erica Dufresne, invited me to give a talk on this idea of the contributions of Arizona tribes and tribes in this region to the unique aspects of the civil rights struggle in the 1960s for Indian tribes. There is a very important and compelling story of Indian struggles for rights under the Constitution that's a part of the broader narrative and stories of the civil rights era. But it's much differently inflected, and the goals are much differently understood and interpreted and misunderstood today. And I think many of the misunderstandings that the dominant society has about Indian tribes and reservation life stem from some of the issues that bubbled up during the Civil Rights Movement that the Supreme Court itself had to deal with in a very particularized Indian context, which made the civil rights discourse and the way we talked about civil rights seem somewhat problematic. And so one of the things I'll try to emphasize today is the rather problematic nature of Indian rights under the Constitution that was being played out before the Supreme Court in the 1960s and 70s. Now, I want to kind of give all of us sort of a working vocabulary, a working understanding of the basic principles of American Indian rights under the Constitution and the Bill of Rights, because that's what we're talking about, our minority rights under the Constitution and the Bill of Rights. I can teach you everything you need to know about American Indian rights under the U.S. Constitution in about 3 seconds. The only place Indians are mentioned is the Indian Commerce Clause. Okay, I always tell my students, to the founders, Indians were a business proposition. They just wanted to get your land. And so the only thing the founders cared about was getting control of Indian commerce under the Constitution. And so really the only place Indian tribes are mentioned is called the Indian Commerce Clause, which gives Congress the power to regulate commerce with the Indian tribes. And that's it. That was the only guidance the founders gave us. And you know, they actually locked up their deliberations at the Constitutional Convention for a period, I think it was more than 50 years. They didn't want to have anybody read what they discussed at the Constitutional Convention. The deliberations, the materials collected by Max Ferran, the famous set of Constitutional Convention deliberations, were locked away until they were all dead. And yet, if you go to those documents to try to find out what they said about Indians, not much help at all. It seemed that the founders were pretty much in agreement. There was a very strong consensus about how to govern Indian rights. It was such a broad consensus, it was such a common understanding that you didn't have to even talk about in the Constitution, because everybody knew that Indian rights were regulated by the doctrine of discovery. That had been the doctrine that Europeans had adopted since Christopher Columbus had come to the New World and discovered lands occupied by infidel, heathen, or savage peoples. That was the law of nations for Europe in the Middle Ages and the Renaissance, when Christian princes came upon lands occupied by heathens, infidels, and savages. Those peoples were in violation of natural law. So therefore they had no rights that a Christian prince had to recognize, and that of course included property rights. In fact, under the doctrine of discovery, when Spain or England or France or Holland or Russia and Alaska claimed land occupied by savage tribal peoples, that land became theirs. They had the superior sovereignty, the right to rule over that land. And as part of that right, they could decide amongst themselves within their own domestic law how they would treat Indian rights. And so this exclusive power to define Indian rights under our system of government is called the Congressional Plenary Power Doctrine. You don't need any other language in the Constitution about Indian tribes, because under the doctrine of discovery, and all the founders talk about the doctrine in their writings, in their speeches, they all were familiar with this because it was title to America, was based on their discovery claims claimed through the English crown. This was part of their legal world. This was part of their political world. This was part of the law of nations. This was incorporated into the Constitution. And so Congress, under the doctrine, had plenary power. Now, interestingly, I always ask my students, can you name the 3 areas in the Constitution where Congress has plenary power? If you can understand just how important Indian issues were to the founders. Congress has plenary power, which means unreviewable by the judiciary. It's a political question. Congress has plenary power over the declaration of war. You can't go to court and try and stop Congress from declaring war. It's under its plenary power. Congress has plenary power over immigration. If you're in Guantanamo, you can't go to the Supreme Court and claim your due process rights are violated, because Congress has plenary power. Congress has plenary power over Indian affairs, because at the time the Constitution was framed, the United States considered itself at war, for the most part, with Indian tribes over the lands of America. And where they weren't at war, tribes were seen as a domestic threat for their capacity to align with England, now safely, supposedly over the border in Canada, Spain to the south, France to the west. And so you better darn well give Congress plenary power, meaning to do whatever it wants. You better give Congress plenary power over Indian affairs because the nation's survival depends on Congress's ability to do whatever it wants. The third understanding that the founders had of Indian rights was embodied by this idea called the inherent sovereignty doctrine. Tribes have inherent sovereignty. How many people have you heard, Indian tribes saying, we're sovereign nations. We fight for sovereignty. That's where it comes from. Interesting that Indian tribes aspire to a word that originates in 12th century Norman conquest of England. How they had sovereignty when it was invented as part of the Norman law of conquest is beyond me, but it's the word that Europeans used to describe this all-encompassing power to do whatever you want. A famous political theorist named Carl Schmitt said that sovereignty is the power to define the exception. Sovereignty is the power to define the exception. And that's what the European powers asserted. And so the inherent sovereignty doctrine says that tribes continue to do what they were doing before we came here unless we say they can. Whatever hasn't been taken away remains. So tribes can continue to regulate their laws of inheritance, family law, domestic law, internal property relations. Tribes can govern themselves, this principle of internal self-government. But their external relations are governed under the doctrine of discovery by congressional plenary power. So until Congress takes away a tribal power, so you come here to Arizona, the Tohono O'odham claim the Santa Cruz River by right of inherent sovereignty. We've always controlled the Santa Cruz River. Nobody's contested us. Anyone tried to keep us away, we fought them off. The Mexicans came here, we fought them. We claim sovereignty, but that Army cavalry's pretty big, and you've asked us to sign a treaty. So we will give up our claim of sovereignty over that river in exchange for other promises, a right to use the river. And that part that we continue to use, we have control over. That's what treaties are. Treaties are this reciprocal bartering and trading of sovereign powers with the Indians usually in the bottom position. But those powers not taken away. For example, you'll find no treaty from the 18th century which talks about casinos. So if the treaty doesn't say anything about a right not to engage in casino gaming, tribes can still do that today. Whatever hasn't been taken away remains. So you look to treaties, statutes, all aspects of Congress's plenary power. If Congress hasn't exercised its plenary power, then tribes can still keep doing it. That's called the inherent tribal sovereignty doctrine. Now the courts have also adapted from the doctrine of discovery this notion that the reason Congress has such awesome power over Indian tribes is because they're not as civilized as white people. And they need to be protected from white people for that very reason. They drink, they lose their land, they get ripped off, they get mad, they go to war, we have to raise armies, they make alliances with our allies. We better place these people under a special relationship that we wouldn't place American citizens under. Indians were not made citizens of the United States until 1924. They weren't aliens. You can only be an alien if you came here from somewhere else. The courts basically, when asked, well, what is the legal status of Indians? They said sui generis. Not really citizens, not foreigners, they're Indians. And the trust doctrine imposes upon the federal government an obligation to deal with them fairly. If you're going to take control over their property, if you're going to create a reservation and take away their right to sell part of that reservation because they get ripped off by the state residents, then you're under an obligation of trust to manage that. If you're going to lease out that land for an oil well that's found there, or if you're going to lease out that land to a rancher and collect that lease payment, you're under an obligation of trust to make sure the Indians get that. Now the problem with the trust doctrine and the guardian-ward relationship is, if you give money to your bank, they're in a trust relationship, they're in a fiduciary relationship, and if they lose it, you can sue them. However, if you give money to the government to manage for you and they're in a trust relationship, you can only sue them if the government gives you permission under the doctrine of sovereign immunity. For 200 years, the United States government never waived its sovereign immunity to Indian suit except by special legislation passed by Congress. The only way Indians could ever sue the government for wrongs committed under the trust doctrine was by Congress admitting, yeah, we probably screwed you over, we'll let you go through the Court of Claims and then appeal to the Supreme Court. That's why for so many years, so many of these Indian claims, the Cobell litigation, the billion-dollar settlement some of you may have heard about, all a result of the failure of Congress to waive its sovereign immunity under the trust doctrine. So I've just taught you Indian law. That's what I spend the semester. The doctrine of discovery says the European discoverer has superior sovereignty. As an aspect of that sovereignty, we've interpreted that under our Constitution as giving Congress congressional plenary power, unappealable. If Congress breaks a treaty with a tribe, the Supreme Court has held consistently that's a political question. We can't hear it unless Congress then goes and passes a statute saying you can sue us for breaking your treaty. The inherent tribal sovereignty doctrine says that whatever isn't taken away remains. And then the trust doctrine says that Congress has the relations of a guardian to its ward in managing Indian property and Indian affairs, but cannot be sued unless Congress so consents. And then the final piece of this puzzle is that when tribes, here's a question, and you all know this answer when I tell you. You will know this answer and you'll be so surprised you didn't know this. Think about it really hard. Think about all the Indian treaties. Even if you've never read an Indian treaty, you'll know the answer to this question. Think about all the Indian treaties you've ever read, and think about all the Indians that have signed them. And those signatures of all the members of the tribe are at the bottom of every treaty. And I saw the figure once, it was amazing. Do you know 90% of those people had the exact same name? Can you tell me the exact name of 90% of the Indians that signed all the treaties ever negotiated? Mr. X. X. Okay. So courts recognizing that Mr. X didn't know what the hell he was doing and had no idea what he was giving up, have created what are called canons of construction. That when you look at an Indian treaty, recognize the circumstances under which it was negotiated. Recognize that Chief Manuelito was pleading for his people. The Navajos down there at Bas Redondo, who had been forced marched down there away from the four sacred mountains. And his people were dying. And he went to General Sherman and said, you've got to give us a treaty and get my people back there because we won't make it. We're dying. We'll do anything you want. We'll give in our arms. We'll start herding sheep. We'll make rugs and make a lot of money off of it. We'll open up our hogans to German tourists. Whatever you want, please. And the courts, recognizing the tremendous imbalance of power, have said, you know, when we get an Indian treaty, we're going to interpret it as the Indians would have understood it. And that was Indian law, in fact, as laid out by the greatest Chief Justice of the United States Supreme Court, Justice John Marshall. Marshall was a founder. At 21, he served as Washington's aide-de-camp at Valley Forge. He was there when Washington was cleaning his teeth and complaining about Congress not giving him appropriations to get out of that damn winter hole. He knew all about federalism. He was given the charge of getting the Virginia legislature to ratify the Constitution. He was a founder. He knew. And when he becomes Chief Justice, he gets to decide the first case ever in American law on Indian rights. Do Indians own their land so that they can sell to whomever they please? If an English citizen comes over the mountains to buy their land, can they sell it to him? If a Frenchman comes over, a Jesuit, to buy their land, can they sell it to him? If an English resident of the colony of Maryland comes over, can they sell it to him? Or can only the king or those sovereigns that have passed to the king's rights purchase Indian land under the doctrine of discovery? In other words, Marshall is asked in the great case of Johnson v. McIntosh, if you become a first-year law student, this is often the first case you read, because you know why? This is where title starts in America. All of our property rights begin with this decision. That's how important it is. Because what it says is that all property starts with the United States government under the doctrine of discovery. Indians have no property rights unless recognized by Congress. So therefore, Indians can't sell anything to anybody. They have no title, no legal rights that can be recognized in a court of law. On the discovery of this immense continent, Marshall says, the great nations of Europe were eager to appropriate to themselves so much of it as they could respectively acquire. They all wanted it. Its vast extent offered an ample field to the ambition and enterprise of all, and the character and religion of its inhabitants. They were savages. They were infidels. They were heathens. They were uncivilized. They were barbaric. They had no property rights. Afforded an apology for considering them as a people over whom the superior genius of Europe might claim an ascendancy. But they all wanted the same thing. They wanted Indian land, and so they had to agree on a principle, or else they'd be at war with themselves, and that wouldn't be very efficient. And that principle was that discovery gave title to the government by whose subjects it was made against all other European governments. And there it is. In 1823, Justice Marshall incorporates the doctrine of discovery into the first Indian rights case in the United States, Johnson v. McIntosh. And this is how we get the origins of the Congressional Plenary Power Doctrine. Remember, I told you how the Congressional Plenary Power Doctrine is related to the doctrine of discovery. Marshall says in Johnson, the exclusion of all other Europeans gave to the nation making the discovery the sole right of acquiring the soil from the natives and establishing settlements upon it. Nobody messed with that right. And from here on in, what rights did Indians have? Those relations which were to exist between the discovered and the natives were to be regulated by themselves. The rights thus acquired being exclusive, no other power could interpose between them. Boys and girls, congressional plenary power. That's where it comes from. It's embedded in Marshall's first decision of the rights of Indians under the Constitution. What about the sovereignty and trust doctrines? Where do they come from? Again, Justice Marshall, in the early history of the nations in the famous Cherokee cases, lays out these fundamental principles. The case begins in 1785 with the federal government under its plenary power negotiating treaties with the tribes of the West. The Cherokees, the Choctaws, the Chickasaws, up north, the Iroquois tribe, the Oneida, the Seneca, to the Midwest, the Potawatomis, the Delawares. That entire chain of mountains, the Appalachians, and the tribes on both sides of that chain were approached, and the United States had just defeated Great Britain. Most of the tribes had sided with Great Britain. They had thought that George Washington, the great father, had proven to be a great warrior. If he beat the king, imagine what he'd do to us. All these crazy Southerners in the red states and even some of the Northerners want to come on our lands and invade our territories and cross the Appalachians. The states are saying that they're going to kill us for siding with the British. We need protection. Who are we going to turn to? The United States government, the great father, George Washington. The tribes signed treaties with the federal government because they were afraid to death of the new states, who basically wanted their Second Amendment rights. The purpose of the Second Amendment are many, but clearly two of the primary purposes were to allow the states to suppress slave rebellions and to fight Indian wars. And the southern states were afraid to death of Indians on their borders. And so the only way that the Indians could be protected was to place themselves under the protection of the Great Father and sign treaties with the federal government. And so the treaty with the Cherokees is almost identical. It's boilerplate to all the early treaties that were signed. Article 3, the Indians place themselves under the protection of the U.S. And I always ask my students, from who are you being protected from? The states. Article 5 preserves inherent tribal sovereignty. If any citizen of the U.S. attempts to settle on your lands beyond the boundary we've drawn by this reservation, the Indians can punish him. Not a good thing. If you were caught trespassing on Indian land. Everybody knew what that meant. Article 9, for the benefit and comfort of the Indians and the prevention of injuries and oppressions on the part of the citizens, Congress shall have the power of managing all their affairs, meaning this is tied in simultaneously with the Constitution that's being drafted. This is 1785, 1787, the Constitution is drafted. You can begin to see how the treaty policy is going to be integrated with a much stronger federal government coming out of the Constitutional Convention process. That this idea of Indian commerce and the acquisition of Indian land has to be centralized in the federal government is one of the lessons that comes out of the Revolution. And so the Cherokees, having signed this treaty, this was the original extent of their Aboriginal territory before white people came. By 1791, that territory had been reduced by more than a half. And by 1838, at the time of removal, they had been basically relegated to a small, tiny parcel. Even though the treaties, a succession of treaties, had made the same promises that I just read to you. If this is protection, don't let me have any of it, thank you. And so finally, Andrew Jackson is elected, Democrats. Many of you are Democrats would be ashamed of the origins of the Democratic Party, let me tell you. But Jackson rode in on a wave of getting the Indians out of the South. The federal government, made up of mostly Whigs and people who would later become Republicans, had actually fought the removal of the southern tribes because they knew it would open up these vast areas of agricultural land to large white plantation slavery settlement. So the abolition movements and the Indian removal movements were closely integrated. If you look, many of the early abolitionists were also involved in the Indian rights movements of the antebellum period. And so the Cherokees say, we're not going to give up any more land. They go to court before Justice Marshall, and they sue the state of Georgia. And they try to sue under a constitutional clause, because remember we said the Indians aren't mentioned anywhere in the Constitution. And in the part of the Constitution spelling out the Supreme Court's original jurisdiction, there's a clause in there which says that foreign nations can sue states. Doesn't say anything about Indian tribes suing states. Doesn't mention them. And so the Cherokees go to their lawyer, former Attorney General for Thomas Jefferson, William Wirt, and says, get us into court. How can we sue the state of Georgia from invading our lands and exercising jurisdiction? How do we do that? And William Wirt's looking at the Constitution. I'm going to have to argue you're foreign nations. Oh, good luck with that. We're not foreign nations. We're infidels, heathens, and savages. How are you going to pull that off? Don't worry. I don't even think Georgia's going to show up. They didn't. So I tell my students, imagine you going into moot court and the other guy's got the flu. I mean, you think you're going to roll that day, right? He lost. Georgia doesn't even show up. And there's no way the Supreme Court is going to accept the argument that Indians are foreign nations. They're regulated by the doctrine of discovery. They're under congressional plenary power. And so though the Indians are acknowledged to have an unquestionable and heretofore unquestioned right to the lands they occupy, until that right shall be extinguished by a voluntary cession to our government. Yet it may well be doubted whether those tribes which reside within the boundary of the U.S. can with accuracy be denominated foreign nations. And here he's riffing. I got to make something up. Let me see. They may more correctly perhaps be denominated domestic dependent nations. I've tried to track that term. It's never been used before in the history of Western civilization prior to this case. Marshall made it up. Just made it up, and it's stuck. We're domestic dependent nations. Justice Marshall said so. Where did he get it from? I made it up. Okay? Domestic dependent. Again, remember when I told you what the Supreme Court said, what are Indians if they're not citizens and they're not foreigners? Sui generis. This is just one of those things that lawyers do. If you've got something that keeps jumping around from category to category, make up a new category, put the lid on it, and put it away. Domestic dependent nations. They occupy a title to which we assert a title independent of their will. So you see the inherent conflict, which takes effect in point of possession when their right of possession ceases. Meanwhile, they're in a state of pupillage. They're totally under our plenary power. So Wirt goes back to the drawing board and says, okay, that didn't work. Let's try another approach. We'll go back next year and we'll argue that when Georgia locks up a white missionary for preaching to the Cherokees on their own reservation territory guaranteed by that Treaty of Hopewell. Remember the Treaty of Hopewell? That Treaty of Hopewell, the Cherokees said, gives us the right to determine who can come on our land and who can't. And if we want a white missionary to come on our land and say, don't go to Oklahoma, you'll become a Sooner, for God's sake. We're not going to go. Georgia arrested the white missionary. And so Wirt says the best way to protect Indian rights is to get a white guy in trouble. So Wirt goes to the Supreme Court suing for the white missionary. And his argument for the white missionary is that the state of Georgia has no right to imprison somebody for going on to the Cherokee Nation because it has no jurisdiction. It has no authority. The only entities that have authority and jurisdiction on the Cherokee Nation are the federal government by virtue of the Doctrine of Discovery or the tribe itself. And Marshall buys this argument in one of the most famous phrases of federal Indian law. It's where this idea of inherent tribal sovereignty that we talked about really begins, and why it's so deeply embedded in American law. And even though Indians aren't mentioned in the Constitution or Bill of Rights, the point that I want to develop here is this idea that these principles from the Marshall Trilogy are carried through by Indians into the 20th century civil rights movement. Because what we're going to see, unsurprisingly, is that as America moves into its most racist period dominated by social Darwinism, eugenics, Jim Crow, lynchings, Indian schools, Chinese exclusion, women can't even vote. This period that the sociologists Omi and Wynand call white racial dictatorship. That from the Civil War until the Civil Rights era, America was a white racial dictatorship, as defined by the idea of one elite class having privileges and legal status that other classes do not. And Marshall declares in 1832, the Cherokee Nation is a distinct community, occupying its own territory with boundaries accurately described, in which the laws of Georgia can have no force, in which the citizens of Georgia have no right to enter but with the assent of the Cherokees themselves, or in conformity with treaties and with the acts of Congress, by acts of congressional plenary power. The whole intercourse between our nation the whole intercourse between the United States and this nation, the Cherokees, is by our Constitution and laws vested in the government. So there's the Cherokees' great victory before the United States Supreme Court, and Andrew Jackson says, at least reported by Horace Greeley, John Marshall has made his decision, now let him enforce it. And as we know, having won in 1832 in the Supreme Court, this great civil rights victory for Indian tribes, 6 years later, General Sherman, once again, marches the Indians at the point of forced bayonet on the Trail of Tears to Oklahoma, where they became Sooner fans. And that, in fact, unfortunately, represents the stories of Indians as a minority in this country for about the next 100 years, until the Civil Rights Movement. In fact, most of the territory lost by Indians in this country was not lost by Indian wars prior to 1860. Most of the Indian wars were over by 1868. The majority of lands lost by tribes were the result of voluntary breaches of treaties by Congress, in which Congress said, we've given you 144 million acres in over 300 treaties. That's way too much. We're going to cut that down under the Allotment Act to about 40 million acres. Under one single piece of legislation, the Allotment Act of 1887, Congress expropriated over 100 million acres of Indian land. Not one bullet was shot, not one arrow was flung. It was all done by law, and the Supreme Court's adherence to this structure that I've talked about, of congressional plenary power, of the guardian-ward relationship, and of the trust doctrine, which could not be sued. And so a classic case of this period, the height of congressional plenary power in Indian affairs, is Kagamah. No treaty says that Congress can exercise criminal jurisdiction on a reservation when an Indian kills an Indian. Up until this point, in fact, the Supreme Court has said when an Indian kills an Indian, it's their business. It's part of their inherent sovereignty. And remember the rule, whatever hasn't been taken away remains. After that decision came out, Congress passed the law saying we overturn that decision. From here on in, the U.S. Attorney has crimes over felonies on the reservation. And Kagamah tests the constitutionality of that statute. Remember, class, this is where I'm getting my drill. Remember what I said? The Constitution only mentions Indians in the Indian Commerce Clause. So here's the question for the court in Kagamah. Congress passes a criminal code for Indians. How does a criminal code of murder, rape, arson have anything to do with commerce? It's unconstitutional, Your Honors. This would be a usurpation by Congress. This is a government of enumerated and limited powers. That's the argument you're making to the Supreme Court. And you know what the court says? You're right, but sovereignty is the power to make the exception. It's not in the Constitution, but Congress can do it anyway under the doctrine of discovery, congressional plenary power, the trust doctrine. These Indian tribes are wards of the nation. They are dependent on the U.S., dependent for their political rights. They know no allegiance to the state. In fact, because of the local ill feeling, the people of the states where they are found are often their deadliest enemies. Go down to Camp Grant, go down to Arivaca, go to Wounded Knee, go to Sand Creek. Those are all state militias in most instances. Disorganized state, local militias. The people of the states, where they are found, were their deadliest enemies. That's the story of civil rights in this country. The reason the federal government and the Voting Rights Act came in was because the states are often and have been the deadliest enemy of minority rights. We know in this country that racial power is most effectively organized at the state level. And we see that replicated today with women's reproductive rights, with gay rights, with minority rights. The strong role of the federal government is represented by the legacy of the Voting Rights Act, shows you what the role of that government must be, to break down these concentrations of white racial dictatorship that are part of our history, and anybody who looks at the history can't deny that. So even as late as 1955, the year I was born, the Supreme Court in a case like Tehitan can ask, do Indians have property rights under the Fifth Amendment? One of your basic civil rights is your right to just compensation when Congress or the legislature takes your land. And the Alaska Natives were sitting on top of a lot of gold, of oil, and other strategic minerals, and timber, and other natural resources. And the government started cutting down trees. And they said, well, we own this land, we've been here forever. And you've never even signed a treaty with us. And now you're just cutting down the trees, and the next thing you know, you're going to take the oil, and we'll have nothing. And that's a violation of our civil rights under the Constitution. You can't take our lands without a treaty. And the Supreme Court, the year after Brown v. Board of Education, this is the exact same court, the same composition that decided Brown v. Board of Education. The line of cases adjudicating Indian rights on American soil leads to the conclusion that Indian occupancy not specifically recognizes ownership by action authorized by Congress may be extinguished by the government without compensation. Every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sale but the conqueror's will that deprived them of their lands. You know, get out of here. Don't even kid me about treaties. They're a joke. They have no legal status under the Constitution. You get nothing. Bye. The year after Brown v. Board was decided. But things were happening. In fact, the beginning of the civil rights movement coincided with an era in which many Indians had returned from World War II and had left the reservation for the first time. There were urban relocation programs where Indians were going into the cities, and they started looking at TV, and they started reading the newspaper, and they started participating in demonstrations. They said, how does this civil rights era, how does this Martin Luther King guy, how does this Cesar Chavez guy, how does this Gloria Steinem woman, how does that relate to what we're going through? And I was sort of right on the edge of that generation, and I remember talking to a lot of folks who were involved. You know, the great thing about being an Indian in my generation is that all your older cousins were at Wounded Knee and Alcatraz. There must have been 200,000 Indians at Alcatraz. Everybody I know was there so they could tell me all these great stories, you know? And they all say the flag. They all talk about the flag because that's so they all know about the flag. But in any event, Indians start picking up people like Vine Deloria and Hank Adams and the Bellacourts begin to see how we translate this civil rights discourse of individual rights, of integration, of blacks looking to the federal government for protection of their fundamental freedoms. And how does that comport? How is that different? How does that problematize the types of things that Indians are looking for? And so we had these confrontations like Wounded Knee. We had books that literally jumped onto the bestseller lists and transform consciousness, like Bury My Heart at Wounded Knee, and Vine Deloria's God is Red, and Custer Died for Your Sins, and Floyd Westerman breaking the top country 40 with his song Custer Died for Your Sins, and Tell Them, Willie Boy is Here, and a lot of other movies, and the occupation of the BIA. And the Indians start bringing their cases. And I think one of the most interesting cases is Morton v. Mancari, 1974, because it sort of shows you how the civil rights discourse for African Americans wasn't necessarily harmonizing with the types of rights discourse that Indians were talking about. 1974 is really at the tail end of the civil rights movement in the Supreme Court. In fact, the Supreme Court is going to hear Bakke in about 2 years, and an early case called DeFunis, testing affirmative action at University of Washington, comes before the court. And it's pretty clear the case becomes moot because DeFunis graduates, but it looked like the votes were there to overturn affirmative action for minorities as reverse discrimination. And so you begin to see Bakke and the anti-affirmative action cases starting to percolate through the circuits in the early 70s. And the court beginning to retrench on some of the dramatic advances of the civil rights movement. And along come Indians, and they bring this case that's basically affirmative action for Indians in the BIA. And people say, why are you bringing that case? There's no way you're going to win. Nixon has got Rehnquist on there, and the court's very skeptical. Say, well, Indians are different. When we ask for affirmative action in the BIA, it's different. And their argument is, in fact, that we don't want integration. Okay? We don't really care all that much about our free speech rights in the New York Times. We're not really focused on, just compensation for our home that's going to be taken for a large industrial auto plant in Brooklyn or Detroit. We want sovereignty. Okay? We want control over our schools. We want control over education. We want control over our resources. We want our land base validated. And all those things are done by the BIA, and we want Indians doing that. So we want you to extend affirmative action to promotions in the civil service at the BIA in 1974. And you have to realize this has nothing to do with all that stuff you've talked about with affirmative action under the 14th Amendment in the Bill of Rights. This is totally different. And so we're going to hope you can understand. And the court, in fact, does understand. Morton v. Mancari justifies the hiring preference of the BIA not under the Constitution, but under Justice Marshall's decision. Plenary power Congress to deal with the special problems of Indians. Remember I said sui generis. You notice this is the strategy. When Indians don't fit, you sort of create this sui generis status. This court has described the origin and nature of the special relationship in the exercise of the war and treaty powers. Remember we talked about plenary power, war, immigration? The court is going back to historical context. And took possession of their lands, leaving them an uneducated, helpless, and dependent people needing protection. Of necessity, the United States assumed the duty of furnishing that protection, and with it the authority to do all that was required to perform that obligation. And the court upholds affirmative action under this notion that these principles we've talked about give Indians a special status which requires a special type of constitutional analysis. Now in the last 10 to 15 minutes, I have till 6, but I'm not going to keep anybody that long, and I thought maybe speak to maybe about 5 or 10 after 5 and then open it up for questions, so to give you a sense of where we're headed here. If you look back at the history of the civil rights era in the Supreme Court, you find, in fact, that Arizona tribes played an absolutely critical role in reviving these principles that I've talked about. So my basic thesis is that the Marshall Model and its ideas of inherent tribal sovereignty and a strong trust doctrine, balanced by congressional plenary power to do good for tribes, to enable tribes to recognize their rights of self-determination, control over their lands, that those principles which are articulated early on in the Marshall era and then had gone into desuetude and disuse in this period of racial dictatorship from the Civil War era till the Civil Rights era, are revived as part of the Supreme Court's general reevaluation of civil rights law in the 1960s for African Americans and other minority groups. But that the court is sensitive to the historic nature, the unique nature of the tribal-federal relationship, and begins to carve out a very special status for tribes different from other minority groups. They carve out a right to a measured separatism, as my colleague Charles Wilkinson. And that in doing that, reaffirm the Marshall principles embedded in the Constitution and the Doctrine of Discovery, and that Arizona cases and Arizona tribes played a critical role in this reappraisal and reaffirmation of these fundamental principles. So, for example, the modern tribal sovereignty doctrine. Without the modern tribal sovereignty doctrine, we don't have tribal courts. We don't have tribal governments managing reservation resources. We don't have tribes handling issues of Indian child welfare. We don't have tribes building multi-million dollar enterprises and casinos. That doctrine, as I've shown in cases like Kagama, was basically ignored by the court and society for 100 years. And then in 1959, really there at the beginnings of the modern civil rights era, 4 years after Brown, what my colleague Charles Wilkinson calls the first great modern era case, Williams v. Lee, is issued by the court, and Justice Black, who has a very interesting history in the civil rights era. Some of you may know that Justice Black was a member of the Ku Klux Klan and was nominated for the Supreme Court, and his defense was, well, I was a country lawyer in the South, and all the juries were made up of Klansmen, and the judge was made up of Klansmen, so it was in the best interest of my client to belong to the Klan. And he got away with it, and turned out to be really one of the most important justices on the Supreme Court in the court's 1960 civil rights era decisions. Just an incredibly progressive voice. So you can never really judge a leopard by its spots or where it came from, and actually had a very important role in many of the court's major decisions in Indian rights. A guy who comes from the South, didn't know anything about Indians, but is educated in the course of arguments and briefing about this unique nature. And the issue in Williams v. Lee is, and this is a common problem on the reservation, there's these Indians live on the reservation, and they want to buy a washing machine, or they want to buy a car, and they fall behind on the payments, and the off-reservation car dealer, or Sears, or Montgomery Ward's, goes and sues them in state court in Flagstaff for the debt. And of course, they don't show up, they get a default, and then they come out there with the sheriff onto the reservation to serve as a process and repo the car or take some other property. Incredibly disruptive, dangerous when you have armed sheriffs coming out there with white guys taking back your cars. And the Navajos had their own court system to deal with it. The contract was made on the reservation. The Navajo defendant who owed the debt lived on the reservation, and this guy was bringing cases as a regular matter of course, using the Arizona courts to collect. And People's Legal Services, one of the early legal services organizations, very important in the civil rights era, brings this case, Williams v. Lee. And Justice Blackmun, citing the Marshall cases, says essentially, absent governing acts of Congress, the question has been whether the state action infringed on the right of reservation Indians to make their own laws and be ruled by them. So you can begin to see this revival of these principles that had sat unused for 100 years that we had gone through earlier with those Marshall cases and the Cherokee treaties, and the court taking another look and seeing whether they have relevance and saying, yes, they do. There can be no doubt that to allow the exercise of state jurisdiction would undermine the authority of tribal courts over reservation affairs. The cases of this court have consistently guarded the authority of Indian governments over their reservations. Congress recognized its authority in that treaty, which is interpreted, that was the same treaty I told you about with Manuelito and General Sherman. It's certainly a treaty in which the Navajos were quite desperate, but the court interprets it liberally under these canons of construction that I talked to you about, recognizing the unique historical circumstances. Probably one of the most important cases in natural resources in all of United States constitutional jurisprudence decided during the civil rights era involves Arizona v. California, the general stream adjudication for the Colorado River. This thing had been going on for decades. This was the litigation that really determines the geography of the West, how this water would be divided. We now see Las Vegas, Reno, Phoenix, Yuma, Tucson. Without cap, without turning around the Colorado and making it run the other way and distributing that water, you wouldn't have the Southwest as we know it today. And along come Indians. They say, you know, we've got these treaties. And unfortunately, the treaties, because they were negotiated with a lot of guys that signed X, don't mention water rights. I wonder why that is. Those poor X guys. Mr. X didn't know anything about water rights, so it said nothing. And the states are arguing, you guys get nothing because it's not mentioned in the treaty. And the tribes lawyers in the United States arguing against the states under the trust doctrine says, look, we've created these reservations. They're supposed to be homelands. The Indians are supposed to be able to govern themselves there, to grow their own food, to be independent, not to be a burden on the state. And we forgot to include the water. And it's just inconsistent with this idea of trust that Congress would not have impliedly reserved it anyway. What do you mean? Well, it's impliedly reserved. They meant to, and they should have, and they did. So, case over. And then in Arizona v. California, well, wow, how much do they get? I mean, there's only 6,000 San Javier and 10,000 Papago and a lot of Navajos, but that's real dry up there, and they can't use it anyway. How much do they get? They don't get it all? No. Arizona v. California says they get all the water that they can use for the practically irrigable acreage of the reservation. The PIA standard is every water rights lawyers, they go to bed saying PIA. It's what they live by. Practically irrigable acreage. Well, what's that mean? What's that mean? Well, if you live in Arizona and you irrigate, you know that anything under 15% grade is practically irrigable. It meant that the tribes of Arizona had a call on the Colorado River for roughly 3 to 5 times the annual flow. If all the Indian Reserve water rights were recognized for the practically irrigable acreage of the reservations, which comprise almost 1/4 of this state, they would overdraw the Colorado by 5 years. And the Supreme Court in Arizona v. California affirmed that principle from the Marshall Model for Arizona tribes. That precedent now applies to all general stream adjudications throughout the West and has been an important point of leverage for tribes in their water negotiations and settlements. Without Arizona v. California, you wouldn't have CAP coming down to San Javier and to Honolulu. You wouldn't go up there as you drive up and pass Gila River and see all that Pima cotton being irrigated. That case is responsible for the renaissance of tribal agriculture throughout the West and becoming one of the important means of self-government and self-determination and economic self-sufficiency for tribes. The modern trust doctrine, the revival of that doctrine, also has a strong connection to Arizona. My colleague at the law school, Witten Woods, litigated this case for Papago Legal Services down at Honolulu. Every year, the BIA would go in and tell Congress, give us money for Indian health because we're serving all these Indians. We're serving Indians on the reservation. We're serving Indians that live in the city. We're serving Indians that live in rural. We're serving Indians all over the place. And then when these Indians came to get service, they were working, I think, at one of the mines that had been on strike and not living on the reservation. The BIA Health Services told them, well, we can't serve you because you don't live on the reservation. What do you mean? Where's that written at? Well, we don't have a rule. It's sort of an agency informal rule. But you tell Congress every year that you take money from Congress. I know, but, it just doesn't go as far as we thought. And so Woody and the Papago Legal Services and their clients went to the Supreme Court and said, if the trust relationship requires transparency and accountability, the denial of benefits to these respondents is inconsistent with the distinctive obligation of trust and its dealings with these dependent and sometimes exploited people. Before benefits may be denied to these otherwise entitled Indians, the BIA must first promulgate eligibility requirements according to established procedures. That is 1973. That was the dictatorial, heavy-handed methods that the BIA had used for 100 years of racial dictatorship over Indians. And Morton v. Ruiz revolutionized administrative procedure within the Bureau. Again, a strong Arizona connection. Probably the most important doctrine of modern federal Indian law is the preemption doctrine. And that, too, is revival of Justice Marshall's decision in Worcester. Remember, in Worcester, the laws of Georgia have no force in the Cherokee Nation. Remember Kagama, the people of the states where they are found are often their deadliest enemies. Those principles had lain dormant, had not been enforced, had intrusions of state jurisdiction like the Arizona courts issuing repossession orders for contracts negotiated on the reservation. In Warren Trading Post 1965, again at the height of the Civil Rights era, the state of Arizona sought to impose a sales tax on sales made to Indians by Indian traders on the reservation. If you ever been up to Hubble Trading Post or any of the trading, they have a federal license. You just can't open up shop on the reservation. You got to get a federal license under one of the oldest statutes on the books, 1790 Trade and Intercourse Act. And Congress has a comprehensive code of federal regulations. Every aspect is covered by these codes. Rarely enforced, but it's there. If it wants to be enforced, it can be enforced. And Arizona comes in and seeks to impose a state income tax or state tax on gross income, and tries to tax the activities. And the court, again, Justice Black says, Congress has, since the creation of the reservation, left the Indians largely free to run the reservation. Remember this principle of inherent tribal sovereignty. In compliance with its treaty obligations, the government provides for roads, education, and other services needed by the Indians. This state tax would put financial burdens on appellant or the Indians with whom it deals, in addition to those Congress or the tribes have prescribed, and could thereby disturb and disarrange this statutory plan. So insofar as these taxes are applied to federally licensed Indian traders with respect to sales made to Indians, they cannot stand. The judgment of the Arizona Supreme Court must be reversed. That case is continually cited today and used by courts and used by tribes to prevent states from exercising jurisdiction on the reservation. It's one of the most important rights that was won by Indian tribes during the Civil Rights era with a strong Arizona connection. And building on that case, Justice Thurgood Marshall in 1973 writes the majority opinion in the last of the cases I'll be discussing, McClanahan v. State Tax Commission. This time, the Arizona Attorney General's office, there's a dynamic here. You'll notice that my point is that Arizona played a critical role in the early civil rights era in cases brought before the Supreme Court testing Indian rights. Well, that's because of the people in the Arizona Attorney General's office who made it easy for us because they kept on trying to assert state sovereignty. Here's the interesting story, and it's a very little neat detail for the University of Arizona. It wasn't until the 1940s that a lawsuit had been brought to challenge the policy of New Mexico, and the people who brought the lawsuit were then going to bring this lawsuit against Arizona because they had the exact same policy. So this was the test case. And the test case was brought by one of the greatest federal Indian law lawyers in the history of the United States, Felix Cone. He had been Solicitor of Indian Affairs. And Felix Cone brought a case in New Mexico. New Mexico's argument was that Indians weren't citizens of the state, and even if they were citizens by virtue of the 1924 Act, they were wards of the federal government. They did not pay federal taxes, so therefore were not entitled to the benefits of state citizenship, which meant they could not go to the University of New Mexico on in-state resident tuition. And Arizona had the same policy. Arizona treated Indians as wards of the federal government and had to pay out-of-state tuition. And so the New Mexico case finds that to be a clear violation of civil rights laws. And the implication of the case is that all of New Mexico's assertions that Indians were wards of the federal government and therefore were not entitled to any state services were now unlawful. And so Arizona and New Mexico had to start providing state services to Indians on an equal basis. And the Arizona Attorney General's response was to go sue Indians to get money to pay for these services. And so they get this poor little Indian woman up on the Navajo reservation who made, I think it was a couple $100, and charged her. It was like $4. If you read it's like $6 she owed income tax on $6 Arizona state income tax, and for $6 they took her to the U.S. Supreme Court. I tell my students, if you're going to bring a case to the Supreme Court, don't beat up on a little old Navajo lady who makes, $180 a year. Go pick on Phelps Dodge or something like that. You idiots, you bozos. What were they thinking? In the Arizona Attorney General, they were thinking we've got to get revenue. And so we're going to bring these really horrible cases in a court that seems to be really sympathetic to these arguments for reviving these principles. And so Justice Marshall says the beginning of our analysis must begin with the treaties. So remember, I emphasized the treaties. Indian rights really aren't mentioned in the Constitution. The rights are embedded in the treaties. And then the Constitution under the Supremacy Clause and the Plenary Power Clause is what undergirds those rights. The treaty nowhere explicitly states that the Navajos are to be free from state taxes. But you don't read this as an ordinary contract. Remember, my canons of construction. You read these things favorably to the Indians. This isn't an ordinary contract by parties dealing at arm's length with equal bargaining positions. At the time this document was signed, the Navajos were an exiled people. They're some 300 miles east of the area they had occupied. This treaty set apart their permanent home. And then concluding, Justice Marshall states that what the court had said in Kagamon is just as true today. The people, the states where they are found, are their most deadliest enemies. And we need this strong umbrella of federal, congressional, plenary power to protect tribes from state assertions of jurisdiction. So in summary then, I think looking back in retrospect about the contributions of our Arizona tribes to the civil rights era and to the tremendous progress the tribes made and are still making under those decisions, I can give you a few examples of how these precedents in case law have been embodied in statute and legislation and policies. As I mentioned, the Indian Gaming Regulatory Act, which allows all of us to go and lose our money just a couple of miles down the road instead of having to go all the way to Las Vegas, and we get to recycle that money here in our local economy, wouldn't be possible without Williams v. Lee and McClanahan. In fact, in upholding the Indian Gaming Regulatory Act in a case involving a California tribe in the 1970s, the court rested upon Williams v. Lee and McClanahan, those two Arizona cases, as primary precedents. The Indian Child Welfare Act, the Supreme Court is hearing a very important case on that act this term. But that act gives tribes and tribal courts jurisdiction over children adopted off the reservation who maintain a strong connection, cultural, biological, or through membership in the tribe. Without Williams v. Lee and some of the other cases I've mentioned, the foundation for modern tribal courts and their readiness to assume this jurisdiction would not have been present. The Indian Self-Determination and Education Assistance Act passed by Congress under President Nixon in the first term of his administration has transformed tribal governments into entrepreneurs and developers, to managers of their own sustainable resource economies, into taking over education, into taking over their own health arenas. The transformation of the reservation points directly to the Indian Self-Determination and Education Assistance Act, which builds upon those victories. And then even here at the University of Arizona, where our anthropologists and museums deal every day with the critical issue of Native American graves and protection and repatriation, and tribes asserting cultural sovereignty over these artifacts and over remains, would not have been possible with the contributions of Arizona tribes to the modern tribal sovereignty movement. So I think we can be very proud of the contribution that Arizona tribes have made, and in fact the leadership position that we took, our Arizona tribes and lawyers who represented them during the civil rights era. And I do think it makes a really interesting perspective on the Indian side of this important 50th anniversary. So I'm happy to take any questions or comments or personal stories that some of you might have, and we do have some time. So thank you very much.
My facts are a little bit fuzzy, but there is a case going on right now, I think in Glendale. The Indian tribe had conceded some land, I believe, for the state to develop something in return for some other land deals, and now they want to use this extra land to build a casino, and the governor and the Republicans, of course, are fighting them.
Right.
Could you
Yeah, the basic structure of the case was there was a engineering project irrigation, water, and big reclamation project, which ended up taking part of the Tohono O'odham Reservation. And the statute authorizing that taking would allow the tribe to select other public land available at a certain time. And there was other public land available in Glendale, and Glendale, as some officials there thought it would be great to have a casino there because of the development of their own sports complex and industries. And so the tribe has been fighting with the state to site a casino on that lot arising from that sort of historical anomaly. Right? I mean, quite frankly, when Congress passed the statute, they probably thought the tribe was going to be looking for land contiguous to the reservation, but there were no restrictions. And the tribe can make that decision. And again, the tribe's ability to do that, to project its economic presence into Phoenix. That tribe right now, if you go to Trader Joe's at River Road, and if you see that medical center right there sitting on River Road, they just purchased that building. They're beginning to diversify their economy. They're looking for ways to maintain their own political self-determination and cultural self-determination through broadening of investments. So I think that's just one case where you see tribes taking this aggressive posture on the foundation of these cases, which allow them to exercise those types of powers free of state interference. They're going to win that case eventually, too.
The government is breaking the laws.
Yeah.
That was their promise.
And everybody signed in, and everybody was happy, but it's a lot of it has to do with Phoenix politics and things like that. So, good question. Yes, other questions, comments, stories, experiences. Yes. Yeah.
Well, I'm from Bull Brook, the Tucson Reservation, and I know the tribe has acquired a lot of land in that area to the east of us. And is it possible that the tribe can trade land? In other words, we don't care to be in this area, we'd rather be over here.
Yeah. And again, that's why the history, it's important to have a basic understanding of the history to understand all these contemporary issues. So the history I told you today explains exactly the situation you're talking about. Remember I said that prior to the 1887 Allotment Act, tribes had 144 million acres guaranteed by reservations. That was in the 1880s. Then everybody comes over from Europe, you have massive immigration, we're going to need large areas for homesteaders, for these immigrants, and we've got tribes sitting on 144 million acres. What do we do about it? Let's divide up the reservations into 160 and 80 acre allotments to Indian male heads of households, and we'll turn them all into yeoman farmers. And it just so happens that after you do that division, you have 90 to 100 million surplus acres left over. What are we going to do with those surplus acres? Let's give them to white settlers. Okay, so that's the Allotment Act. Turns out to be an absolute disaster. The Depression hits Indian country about a decade before it hits the rest of the U.S. Congress recognizes allotment has been a disaster. What are we going to do about it? Roosevelt is elected in 1932. One of his first major pieces of legislation is the Indian Reorganization Act. And part of the Indian Reorganization Act allows tribes to buy back land and reconsolidate land that was lost through allotment or other suitable lands. So that statute has been sitting on the books, and Congress, under its plenary power and trust doctrine, can justify that extraordinary use of this power to just go and take land out of state ownership or that's in currently federal government ownership and give it to the tribe. So the act sits around from 1934 to about 1980, and nobody says anything about it, because when it's used to reacquire land that had been taken by allotment. And it's usually used for contiguous areas of the reservation, and nobody's too upset. And then some tribes say, well, there's some lawyers, you look at this 1934 act, and it doesn't say we can't purchase land in fee simple in the middle of Detroit or in the middle of Glendale, and then apply to the secretary to put it in trust and make it part of our reservation. It doesn't say we can't do it. And what was my rule, class? Whatever hasn't been taken away remains. Remember, that's why that rule is so important. Since Congress didn't say you couldn't buy land in Glendale and turn it into a casino, until Congress says you can't, go for it. And that's what's happening. So tribes now are using that act that 1934 act to reacquire land, some of which may have been allotted, some of which just may be owned by non-Indians, and they just want to go and apply. And because the legislative intent behind the statute is to allow tribes to expand and consolidate their land base, there is a strong presumption that if a tribe owns land and wants to put it in trust, the secretary ought to do it. How's that? Explain? Doesn't help you. For that, I charge, okay? But that's how you got in the situation you're in. And so that's why tribes like TON are buying up land, some of it contiguous, some of it not, and why it scares the bejesus out of local officials, because they know that tribes have that ability to then go to the federal government and flip that land into trust, which takes it not only off the state tax rolls, but as we've said, the laws of Georgia have no force. If that land is tribal land, Arizona law has no application.
Under present law, the tribe can buy land pretty much anywhere.
And then if they can lobby and convince, and this of course is, you've opened up a wonderful can of worms. If I say the name Jack Abramoff to you, does that mean anything? He was the guy who was in jail for lobbying for Indian clients to do exactly what you're talking. You could be Jack. Yeah, hey, yeah, there's nothing stopping you. You mean you can do it? Yeah, I think so. Let's try it. Pay me $1 million. I'll get the Interior to do it. And that's exactly what happened. What happened was that these big-time lobbyists read that act and said, there's nothing stopping a tribe from going to buy land and then try to get it into trust. And I've got friends on the Interior. I've got friends who sit on the Congressional, House subcommittee. I can get it done for you. So that's, unfortunately, a lot of Indians got caught in that game and ended up getting ripped off for millions. But that's kind of, what developed out of that. So.
And then my other point is it possible for the tribe to say we're not interested in this particular piece of property, we'd rather have this property, and essentially make a trade.
Yeah, land exchanges aren't as frequent. There's provisions for land exchanges, but most tribes are into keeping the land they've got and adding to what they want to add to their land inventory. So Indian land consolidation is one of the major sort of outgrowths of the tribal sovereignty movement, is to strategically acquire land for multiple purposes, for grazing, for agriculture, for wind farms. I know of tribes that are acquiring lands for wind farms because, again, state aesthetic laws and zoning laws don't apply. So there's just lots of ways that tribes are looking to use this very interesting model of tribal rights that comes out of the civil rights era. And I think our discussion is a really good example of how the tribal rights that come out of the civil rights era are much different and much more problematic, because what they allow tribes to do is to use their unique position, their right to measured separatism, to make white people crazy sometimes, to really bother the majority society, to do things that the majority of society doesn't want them to do, and recognize that these are historically oppressed groups that never used to bother us. We had them in control, and now look what they're doing. They're draining our coffers, with gambling addiction, and they're building wind farms. And they're doing all these horrible things that we don't want them to do. Where do they get those rights? Where is it at in the Constitution? And you can tell them. The Constitution only mentions Indians in the Indian Commerce Clause. Can't help you there. And they'll just walk away and say, wow. Yes.
So the proceeds from gaming, the percentage of which goes to the state, is that considered a treaty?
Actually, it's a compact. Very good. So the Indian Gaming Regulatory Act, right? Here's what happens. Remember that California case I talked about, the Cabazon case? The court there, following McClanahan and these other Arizona cases, said Congress has never taken the right of tribes, never taken away the right to gamble and to build casinos, so therefore they can. So as of that date, the world is going to end. Donald Trump is pulling his hair out. Las Vegas is saying it's the end of the world. There's going to be gigantic Indian casinos. We need Congress to exercise its plenary power to overturn that case. And the Reagan administration says, no, we're not going to let you overturn that case, because we're cutting Indian budgets, and we see this as a way for tribes to become self-sufficient. So we're going to draft compromise legislation. And what that legislation says is there's 3 types of gambling that the states and tribes and federal government is concerned about. The first type is social gambling. I mean, the Jesuits used to go crazy because Indians were always gambling, okay? It's part of our culture, okay? And so social gaming has the state or federal government have no say in it. Tribes can regulate social gaming on the reservation. The second type of gaming are slot machines. Okay, games that you don't play against that are just there. You're just putting money in, electronic machines. Those games we are going to require in states that allow such games for charity nights, casino nights. If you allow casino nights for charities, then the IGRA statute says you've got to negotiate in tribes with good faith to allow them to have slot machines. And so those games you have to sign a compact with the federal government and the state that regulate how many you can have. So our tribes, is it 500 many that they have a right to 500. Each tribe has a right to 500 slot machines. And then in exchange for sort of negotiating and backing down and getting the deal through, they agree on a percentage, and will also contribute a percentage. The third type of gaming is called Class 3 gaming, and that's things where dealers' hands are moving and lots of money are changing hands, and where you're worried about mob influence and cash control, and they are also regulated by a much more aggressive compact that I think runs for 3 to 5 years, I'm not sure, and then are renegotiated. And so so again, there's an example. Congress, through its plenary power, has forced states to negotiate these compacts with tribes under the threat that if you don't, we'll approve it anyway. So, but our interest is in having everybody agree on this. So, good question. Excellent. So, in a way, tribes do see those things as treaties. Absolutely. I saw another question or hand. I'm happy. Yes.
I should want to know your take on Ex parte v. Crow Dog, because you mentioned the Major Crimes Act.
Yeah, I didn't mention the case because if I mention cases, and a lot of non-lawyers here, they get up and leave. But in 1883, so remember I talked about Kagama, that was the case which said Congress can pass a Major Crimes Act applying to Indians, even though the only place Indians are mentioned is the Indian Commerce Clause. That overturned an 1883 case in which one Sioux guy killed another Sioux guy on the reservation called Ex parte Crow Dog. And the court held the Sioux Treaty says nothing about you giving up your inherent sovereignty to criminally prosecute your own members. And there's no statute by which Congress has asserted the right to criminally prosecute that crime as well. So therefore, in the absence of a treaty or statute, what's my mantra? Whatever hasn't been taken away remains. And you can ask my students, I don't know if any are here, but many's been here. And I actually have an exercise where we spend about 5 minutes in Indian law, and these are like 23-year-olds, and we just chant, whatever hasn't been taken away remains. And I make them do it for like 3 or 4 minutes. Professor Wins is really weird. But then they come back, that mantra really works, I'm telling you. Whatever hasn't been taken away remains. So that's what happens. Since Congress has not legislated specifically on a criminal code, the tribes can keep doing it. 1 year later, they passed the Major Crimes Act. So does that remain anymore? So can Congress do that? What about the Constitution? Doesn't speak to the issue, sorry. You're controlled by you could all be Indian lawyers, and they're making like $300, $400 an hour now. But it's not a hard business, and I tell my students that the principles are pretty basic, and I think most of you have sort of kind of got onto them. And my hope is that we have a little bit better understanding now of sort of the legal architecture and its integration into the Constitution and the Civil Rights era, the unique position that Indians have. And I think just our discussion today, we're talking about water rights and casinos and land acquisition. This is not what the Equal Employment Opportunity Commission is dealing with. All right? These are things about sovereign nations and government-to-government relationships and how people define citizenship and cultural membership and identity. And these are challenges that our Constitution really wasn't designed to handle, because the founders, to a man, to a person, were absolutely 100% convinced that Indians wouldn't be here within the next century, that they were a doomed race. And Washington, in his first address to Congress, says, the savage as the wolf will retire. Don't worry about making war on the tribes, just buy their land by treaty. Because as civilization approaches the frontier, the game disappears into the forest. And the savage as the wolf will retire. And then they're willing to give up their lands much more cheaply than fighting a war. It's the first document. It's called Father Pruka's classic textbook, Documents of American Indian Policy. The first document is Washington's Savage as the Wolf speech, in which he says, sign a treaty for as long as the grass grows and the water flows, because they ain't going to be here. And that's why all the treaties say that. The whites negotiated them in perpetuity because they were 100% convinced that Indians were a doomed race and could not survive the onslaught of white civilization. We showed them. and I think the amazing story is that we showed them by using the Constitution, by using the courts, by using these horrible racist doctrines. I mean, it's harder to imagine a more racist doctrine than the trust doctrine, that Indians are in a state of pupillage, that they're wards. It's hard to imagine a more racist doctrine than the doctrine of discovery, which says if you're a savage, you have no property rights. And I think the amazing thing, if you're trying to take, the takeaway from this, is Indian people's fundamental belief in justice, and that somewhere the Constitution must reflect some basic notion of justice. And our challenge is to get our notions of justice to match up with the Constitution's notions of justice, to create that space for that measured separatism, which I think is so unique in the battles that Indian people have fought for their ideas and their stories about what civil rights are. Yes, thank you.
Can you explain the issue over water rights in northern Arizona now with the Navajo people against the state of Arizona? I'm not very clear on that.
Well, there's a whole slew of water rights issues in northern Arizona. Again, coming from that original adjudication that I described all the way from 1963, which gave the tribes in Arizona, in fact, all the tribes in the Colorado River Basin, a right to the practically irrigable acreage. Now, the problem with that case was that the Supreme Court in 1963, in its entire history, it had one person west of the Mississippi sit on it, William Douglas. They knew nothing about water in the West. In fact, they gave the case to a special master. And these general stream adjudications have 10,000 plaintiffs. They generate a docket that is millions of pages. And nobody on the Supreme Court wants to touch it, so they give it to a special master, and whatever he says, you validate, because otherwise you got to open the whole damn thing up again. And the special master in Arizona v. California came up with the PIA standard, because he actually understood, water economics and water irrigation. So all the cases adopt that. And nobody stepped back and said, well, the problem with the PIA standard is there's not enough water to go around if that's what you give the Indians. And so Indians have been in this constant battle, particularly in Arizona and the dry West, have been in this constant battle over their rights to what are called wet water and paper water. You hang around water lawyers, they have this weird vocabulary. Oh, that's wet water. I thought all water was wet. Oh, no, there's paper water. Paper water is not wet water? Oh, no, not until it turns to wet. But that was wet. And it's like Abbott and Costello, and they take this seriously, But you see my point, right? So here's been the problem. And this is a problem in minority rights, particularly where a minority rights holder has a disproportionate right to a resource, disproportionate to its proportional representation in the population. Indians have a legal right to more water than anybody can use. Politically, they don't have the leverage because Congress is the only one that can pass a settlement closing these cases. And so John Kyle, one of the last things he did before he left office, and I congratulate him, he said, I'm going to get this issue for the Navajo and some of the Apache tribes resolved. And got a water rights settlement there before Congress. And of course, it raises a lot of issues about the use of that water for Black Mesa, for coal development, for mineral development. The tribes themselves are divided on how that water should be used, whether they should even have it, whether it should be sold to Phoenix and Arizona, whether it should be reserved for agriculture, whether it be reserved for in-stream flows. And so it becomes very difficult to come in there and broker a deal, particularly when the federal government's in a period of deficit and doesn't want to finance these settlements. So that's been the problem that we've had in Arizona and other western states, where it's just been really difficult to negotiate a water rights settlement, particularly in areas with high concentrations of strategic minerals where we know what the highest and best use of that water is. From an economic standpoint, the highest and best use of that water is for the mining industry. And the second is large-scale population centers. And the third is growing cotton on the Gila River Reservation. I don't think so. Okay, but to get back to those traditional economies, those in-stream uses, those sacred uses of water, you can see that competition. You can see how many tribes, their own councils are torn over how we're going to allocate this resource. Are we going to step into the 21st century? Are we going to stay in the 20th? Are we going to go back to our traditions? Are we going to try and figure out how to blend the old with the new? These are real challenges. And the issue is whether this framework that I've outlined can work to help tribes settle that. I think it's a creaky framework in a lot of ways. And it can hold tribes hostage to sort of national elections. You know, the best example we have now, an absolutely tragic example, is VAWA, is the Violence Against Women Act. The Department of Justice, Amnesty International, have collected the statistics. If you're an Indian woman, you're 3 to 5 times more likely to be raped during your lifetime. And in more than 80% of those cases, you'll be raped by a non-Indian. How does this happen? Well, because tribes do not have criminal jurisdiction over non-Indians on the reservation. So if you're an Indian woman raped by a non-Indian, that's an interracial crime. The state doesn't have jurisdiction either. So you have to call the U.S. attorney to prosecute a rape. Now let me tell you, I have students who work in U.S. attorneys' offices. You move up the ladder by doing RICO cases. You move up the ladder by busting immigration rings. You move up the ladder by prosecuting drug dealers. You do not go anywhere by prosecuting rape cases. There's just no gain in it. Go to your U.S. attorney's office, ask them where the rape kit is. Ask them where the number